You're listening to the Valley Current.
The Oakland Federal Courthouse has seen, well, its fair share of dramatic conclusions over the years. But Monday, May 18, 2026, that is going down in legal and financial history as the day the gravity just simply turned off.
Yeah, it really was an unprecedented moment.
Welcome to today's deep dive. We are tackling the final chapter of this titanic legal battle, the verdict in Musk v. Altman.
Right. And to do this, we are pulling our insights from this incredibly detailed, really insider-focused dispatch.
Yeah, from the computer law group LLP newsletter.
Exactly. It's their spring 2026 trial update, the final round edition, penned by managing partner Jack Russo.
And it is an amazing source because, it bypasses all the mainstream media obsession with the personalities.
It ignores the drama.
Right. It goes straight to the structural architecture of what actually happened in that room. And honestly, more importantly, the multi-trillion-dollar shockwaves radiating out from it.
It is essential reading if you want to understand the mechanics of this case.
So our mission today for you listening, it is straightforward, but it is massive. We are going to deconstruct exactly how a grueling 3.5-week trial involving the absolute titans of the tech industry.
The biggest names in the world, really.
Yeah, how it ended in a sub-2-hour blur.
Less than 2 hours. It's crazy.
We are going to look under the hood at the precise legal mechanisms, the specific, unforgiving doctrines of California law that triggered this sudden finish.
Because it wasn't an accident. It was highly technical.
Exactly. And finally, we will map out the ripple effects this verdict had the literal minute it hit the wires.
Clearing the runway for some historic IPOs.
Altering the trajectory of AI governance and forcing this radical new playbook onto Silicon Valley boards.
So whether you are heavily invested in the upcoming tech IPO season or tracking the race toward artificial general intelligence.
Or if you just appreciate the brilliant mechanics of high-stakes litigation, right? Because this case is the ultimate collision of unbridled capitalism and strict legal boundaries.
It really is.
So let's start with the sheer speed and the, frankly, bizarre optics of verdict day.
The contrast between the buildup and the resolution, it is just staggering.
Oh, totally.
You have a case demanding $134 billion in structural disgorgement.
Billion with a B.
Right. You have weeks of intense, highly technical testimony. And then a sudden, almost anticlimactic drop of the curtain.
Let's set the scene for a second. We are at the Ronald V. Dellums Federal Building.
In Oakland.
Right. A 9-person advisory jury, so that's 6 women, 3 men. They receive their instructions.
First thing Monday morning.
Yeah, they walk into the deliberation room. And before the mid-morning coffee break is even over, they are back.
Under 2 hours. It is unheard of for a trial of this magnitude.
Less than 120 minutes. And they hand down a unanimous defense verdict for Sam Altman, Greg Brockman, OpenAI, and Microsoft.
Completely unanimous.
And then Judge Yvonne Gonzalez-Rogers immediately adopts the verdict from the bench. She dismisses all claims as untimely.
Right, and she even openly states to Musk's lead counsel that she was prepared to dismiss it on the spot.
On the spot. But here's the cinematic detail that I just can't get over. None of the main players are actually in the room to hear it.
Yeah, that is the wildest part.
Altman is absent. Brockman is absent.
And Elon Musk is literally on the other side of the planet.
Documented in Beijing, right, with a CEO delegation.
Meanwhile, the defense counsel from Wachtell and DeChert, they are hugging in downtown Oakland.
Popping champagne, probably. And Musk's lead counsel, Mark Toberoff, he walks out and gives the press a single word.
Just one word.
Appeal.
The physical absence of the principles, it speaks volumes about the nature of modern corporate warfare.
How so?
Well, the architects of the conflict, the billionaires funding it, they rarely stand in the blast radius when the final detonation actually occurs. They are insulated.
That makes sense. But I have a really hard time wrapping my head around the timeline here.
The 2 hours.
Yeah. How does a jury sit through 3.5 weeks of highly technical, fiercely contested testimony?
It is a dense trial.
They are hearing from Microsoft CEO Satya Nadella, Ilya Sutskever, Siobhan Zilis, Jared Birchall, Brett Taylor.
Plus 3 full days on the stand from Elon Musk himself.
3 days and 4 hours from Sam Altman. How do you synthesize all of that in less than 2 hours?
You really don't.
Right. Are we supposed to believe they carefully weighed the nuances of AGI safety protocols and the moral philosophy of open source development before lunch?
No, and what is fascinating here is that the sub-2-hour deliberation time, it isn't evidence of the jury ignoring the complexity.
Okay, what is it evidence of then?
It is evidence that the legal system provided them with an elegant bypass around all of it.
A bypass.
Yeah. When a jury returns a verdict that fast on a case of this magnitude, they are not agonizing over the philosophical merits of OpenAI's transition from a nonprofit to a capped profit structure.
They aren't debating AI ethics.
Exactly. They're answering a threshold question. The architecture of the trial presented them with a locked gate before they ever even reached the philosophical battleground.
So they didn't even evaluate whether OpenAI actually betrayed its original mission to humanity.
They didn't have to. The law didn't require them to get there.
Wow.
And this ties directly back to your point about the optics of the empty courtroom.
Musk being in Beijing.
Right. In trial law, optics are inextricably linked to credibility. The core of the defense's strategy was built on this assertion that Musk failed to diligently investigate his own claims in a timely manner.
Oh, okay.
Their argument was essentially, you claim this massive harm occurred, yet you didn't pay enough attention to your own affairs to file a lawsuit before the legal deadline.
So if that is the defense's narrative, Musk being in Beijing during closing arguments, I mean, that seems like a catastrophic unforced error.
It functions as illustrative evidence. The fact finders in the jury box, they absorb that physical absence.
They are sitting there. He isn't.
Exactly. It visually reinforces the defense's argument that this specific legal grievance is not a pressing priority for the plaintiffs.
That makes total sense. If you are arguing that you were too busy or distracted to notice an alleged multi-billion-dollar theft of a charitable mission years ago, skipping your own trial's conclusion to attend a summit in Beijing.
It perfectly encapsulates that exact lack of localized diligence.
Wow. Credibility decides cases.
And presence is the baseline of credibility.
That makes the courtroom dynamics incredibly tangible, which pulls us directly into the doctrinal lever that actually ended the trial.
The calendar.
Right, because the jury didn't issue a moral exoneration of Sam Altman.
Not at all.
They issued a mathematical conclusion about the calendar. The entire decision rested on the statute of limitations.
The ultimate neutral arbiter. It doesn't care about your feelings, just the dates.
So let's look at what the jury was handed. They were instructed on 3 statutory cutoffs.
3 very specific dates.
First, for the breach of charitable trust claim, the cutoff date was August 5, 2021. For the unjust enrichment claim, it was August 5, 2022.
Right.
And for the claim that Microsoft was aiding and abetting, the cutoff was November 14, 2021.
And we have to remember the anchor for all these dates.
Right. The anchor is August 5, 2024. That is the exact day Musk actually filed the lawsuit.
So you count backward from there, depending on the specific claim statute of limitations.
Got it. So the defense's objective was to prove that the alleged injuries happened and were known or should have been known before those 2021 and 2022 dates.
And the mechanism enforcing these dates is a strict California legal standard. It is known as the inquiry notice accrual rule.
Inquiry notice accrual rule.
Yeah, and it is heavily defined by a major precedent called Jolly v. Eli Lilly.
I want to break down how this inquiry notice actually operates because honestly, it is not intuitive for most people.
It can be confusing.
It's like California law functions as a hypersensitive smoke detector.
I like that analogy.
The law says the moment you smell even the faintest whiff of smoke, or the moment that alarm gives off a single chirp, the clock starts ticking for you to get up, walk through the house, and find the fire.
You have an active duty to investigate.
Right. You do not get to sit in your living room for 3 years watching the smoke billow under the door, wait for the flames to physically engulf your sofa, and then decide to sue the home builder for a faulty electrical grid.
That analogy perfectly captures the burden of diligence here. California law absolutely refuses to reward willful blindness or strategic delay.
So you can't just play dumb.
Exactly. The doctrine explicitly states that a plaintiff must actively seek out the facts of their injury. You cannot wait for undeniable documented proof of wrongdoing to be hand-delivered to you on a silver platter.
So the chirp of the smoke detector is enough.
If you harbor a suspicion, the legal clock is already running. And during the trial, the defense uncovered 2 evidentiary kill shots that proved Musk's smoke detector was blaring years before he took action.
Okay, let's talk about these kill shots, because the first one was practically a self-inflicted wound on the witness stand.
It was a brutal moment. in April 2026.
According to the CLG dispatch, Musk testified under oath, and I quote, "I would file the lawsuit sooner if I thought they'd stolen the charity sooner."
Which, sounds like a natural defensive thing to say.
Right. To a layperson, it sounds totally reasonable, but legally, it seems like a trap.
It is a profound logical trap that completely dismantled his own timeline.
How so?
By uttering that specific sentence, he anchored his subjective belief to a strict chronological progression.
Okay, tracking with you.
Defense counsel Sarah Eddy from Wachtell, she weaponized that statement brilliantly.
Yeah.
She used it to demonstrate that every single day Musk delayed filing before August 5, 2021 was a day he implicitly admitted he lacked the requisite belief of theft.
Oh, wow.
Or conversely, if he did suspect it, he consciously chose to sit on his hands.
So it is a lose-lose for him.
Exactly. It completely nullified any argument that the facts of the alleged transition to a for-profit model were somehow hidden from him. He basically said, if I knew, I would have sued. And they proved he had enough information to know.
And the second kill shot was just a masterclass in forensic accounting.
This is where it gets really mathematical.
Because OpenAI didn't just argue about dates. They brought in auditors to track the literal dollars.
Following the money.
Yeah, they demonstrated to the jury that Musk's initial financial contributions to the nonprofit had been entirely deployed toward charitable purposes.
We're talking research, compute, salaries.
Right, and all of that money was spent on the mission long before the statutory cutoff dates ever arrived.
This is a devastating blow to a breach of charitable trust claim.
Why is that so devastating?
Because the fundamental basis of enforcing a charitable trust is that there is a corpus, a body of money or assets that is currently being misused or diverted.
The pot of money.
Right. If forensic accountants can definitively prove that the specific funds you donated were completely exhausted on the exact charitable mission you originally funded, the enforcement theory dissolves.
Because the money is gone.
Exactly. You cannot sue to reclaim or redirect money that has already been legitimately spent on the thing you asked for.
That makes total sense. And this also provided the exact same escape hatch for Microsoft, right?
It did.
Detroit's Russell Cohen argued in closings that Microsoft had zero knowledge of any of these internal nonprofit machinations before the clock ran out.
And because the jury found the claims untimely across the board, Microsoft didn't even have to defend the highly controversial internal memos detailing their leverage over OpenAI.
The calendar acted as a complete firewall.
It shut the whole conversation down.
But taking a step back, just as a layperson looking at this, if you donate tens of millions of dollars to found a charity to, save humanity, shouldn't the legal system give you the latitude to enforce that mission, regardless of a rigid 3-year window?
I mean, that instinct makes sense morally. But structurally. Structurally, it would be a disaster for the nonprofit sector.
Really? A disaster.
Jack Russo's analysis points to foundational precedents in California law. Specifically, cases like Holt and LB Research, which establish incredibly narrow standing for donors to sue charities.
Narrow by design.
Entirely by design.
Yeah.
You have to consider the operational reality of a charity.
Okay.
If any major donor retained the perpetual, open-ended right to sue a nonprofit every time its strategic direction evolved or leadership changed, the entire sector would be paralyzed.
I see what you mean. Nonprofits would constantly be held hostage by the retrospective buyer's remorse of their founders.
Exactly. Every time a founder got mad 5 years later, they would file a lawsuit to freeze the charity.
So who does have the power to step in?
The legal framework intentionally places the primary enforcement power in the hands of the state attorney general, not an aggrieved billionaire.
Ah, the AG is the watchdog.
Right. The strict statute of limitations acts as a necessary shield. It allows charities to operate without the threat of infinite, unending litigation from their past benefactors.
Knowing that framework completely recontextualizes the verdict for me.
It wasn't just a technical loophole.
No, it was the system functioning exactly as intended to protect the corporate entity from a disgruntled founder.
Precisely.
But we have to look at what was actually at stake if that shield had failed, because the sudden stop of the trial preempted the planned remedies phase.
Right, the remedies phase. This is what everyone was terrified of.
This was supposed to be a bench trial phase immediately following the jury verdict, where the judge would decide the actual punishment.
And the remedies phase would have triggered a corporate earthquake unlike anything Silicon Valley has ever seen.
I mean, Musk's prayer for relief reads like a corporate death warrant. Let's look at the three main pillars of what he actually demanded.
It is wild to even read these out loud.
First, he wanted $134 billion in ill-gotten gains disgorged into the OpenAI nonprofit foundation.
Which is massive.
Second, the immediate removal of Sam Altman as CEO and Greg Brockman as president.
Firing the leadership.
And third, the total unwinding and nullification of OpenAI's October 2025 Delaware Public Benefit Corporation recapitalization.
He was basically asking a federal judge to essentially dismantle the architecture of the most highly valued artificial intelligence company on the planet and manually reassemble it according to his original 2015 vision.
Let's talk about the mechanics of that $134 billion disgorgement. How does a company even physically execute a penalty of that magnitude?
You don't just write a check for that amount.
It would mean liquidating intellectual property, voiding employee equity, clawing back investments.
It would completely vaporize the commercial viability of the entity.
It would be corporate capital punishment.
It really would.
Yeah.
And it introduces a fascinating legal hypothetical that the trial narrowly avoided testing: the application of the Supreme Court's doctrine in Liu v. SEC.
Okay, how does the Liu doctrine govern a penalty like this?
So the doctrine establishes that equitable disgorgement, which is the act of forcing a defendant to give up money obtained through illegal or unethical acts.
Right.
It must be strictly capped at net profits.
Net profits, okay. Not gross.
Exactly. A court cannot order you to disgorge gross revenue. You are legally allowed to deduct legitimate business expenses.
Oh, wow. Now imagine applying that standard to OpenAI.
It would be a nightmare.
Figuring out the net profits of their transition from a 501c3 to a capped profit public benefit corporation, while factoring in the billions spent on compute, talent acquisition, and Microsoft cloud infrastructure.
It would require a forensic accounting undertaking of biblical proportions.
It would tie the company up in audits for a decade.
Easily a decade.
But Mark Toberoff, Musk's lawyer, he promised an appeal. So is there a viable path for the Ninth Circuit Court of Appeals to revive this $134 billion question?
The probability is infinitesimally low.
Really? Why?
And that brings us to one of the most brilliant tactical legal maneuvers we have seen in modern corporate litigation, orchestrated by Judge Yvonne Gonzalez-Rogers.
This is the community judgment cover strategy you mentioned earlier.
Exactly.
Let's unpack how she built this fortress around her verdict.
Okay, so a claim for breach of charitable trust is classified as an equitable claim.
What does that mean in practice?
Historically, equitable claims do not carry the right to a jury trial. They are decided directly by a judge in what is called a bench trial.
So just the judge, no jury?
Usually, yes.
Yeah.
However, under Federal Rule of Civil Procedure 39C1, a judge possesses the discretionary power to impanel an advisory jury.
An advisory jury. So the judge essentially drafts a group of everyday citizens to sit in the courtroom, listen to the evidence, and give her their opinion, even though she ultimately holds the final decision-making power.
Precisely. She recognized the immense public interest and the staggering financial stakes involved here.
Yeah.
By utilizing an advisory jury, she insulated her final ruling with the consensus of the community. When the jury returned their unanimous defense verdict in under 2 hours, she invoked Rule 52A1 to immediately adopt their factual findings as her own official bench ruling.
And why does that specific combination of rules make the verdict immune to an appeal?
It comes down to the appellate standard of review.
Okay, explain that for us.
When an appellate court reviews a judge's factual findings under Rule 52A1, they must apply the clear error standard.
Clear error.
This is an incredibly high bar. The appellate court will not reverse the decision unless they review the record and conclude that an obvious, undeniable mistake of fact occurred.
Like 2 + 2 = 5.
Exactly. And because the entire verdict hinged on inquiry notice, which is a concept deeply reliant on assessing witness credibility, interpreting the tone of contemporaneous emails, and judging the demeanor of the billionaires on the stand.
Appellate courts hate touching that stuff, right?
Yeah. They almost universally defer to the trial judge and the jury who were physically in the room watching the witnesses testify.
The appellate judges reading a cold transcript in San Francisco aren't going to second guess whether Elon Musk looked believable on the stand in Oakland.
They won't do it.
So Judge Gonzalez-Rogers essentially engineered a procedural trapdoor that locks the appellate court out of the factual dispute.
It is brilliant.
The CLG dispatch notes the Ninth Circuit might hear oral arguments in late 2026 or early 2027, with a decision mid to late 2027. But the architecture of the dismissal is functionally bulletproof.
It is a true masterclass in judicial risk management.
And the immediate consequence of that risk management was the unfreezing of the global capital markets.
This is where the scale of this story shifts from legal mechanics to macroeconomic history.
Yeah, because the dismissal of this existential threat didn't just end a localized courtroom drama. It acted as the starting gun for what the CLG newsletter identifies as a historic IPO season.
Wall Street investment banks were monitoring this trial docket with the exact same intensity as the tech press.
Oh, absolutely. The timing of the verdict intersecting with the financial calendar is the true hidden narrative here.
Capital markets require certainty, and this trial represented a $134 billion black hole of uncertainty.
Let's break down the sheer gravity-defying numbers here, starting with the plaintiff's own empire.
Musk's companies.
Right. According to the source, SpaceX filed a confidential S-1 on April 1st, 2026.
A massive filing.
They are targeting an enterprise valuation range of $1.75 to $2 trillion, aiming to raise up to $75 billion.
Unbelievable number.
But the structural detail that jumps off the page for me is their plan to offer an unprecedented 30% retail allocation.
That allocation percentage fundamentally alters the mechanics of a traditional initial public offering.
How so? Give us the context.
In a standard mega-cap IPO, retail investors, everyday people trading on platforms like Fidelity or Robinhood, they might be allocated maybe 5 to 10% of the shares.
So who gets the rest?
The vast majority is reserved for institutional whales. We are talking pension funds, sovereign wealth entities, huge mutual funds.
So why would a company targeting a $2 trillion valuation carve out nearly a third of its offering for the retail public?
It achieves two massive objectives. First, it generates unprecedented public buy-in and brand loyalty. It is essentially democratizing ownership of the space economy.
Letting everyday people own a piece of Mars.
Exactly. And second, retail investors are typically less price sensitive and less demanding of immediate short-term yield than institutional investors.
They aren't looking for a quarterly dividend. They are buying the dream.
Right. They are buying into the long-term vision of multiplanetary life, which provides the stock with a highly resilient, cult-like base of support.
And crucially, this IPO includes the absorption of xAI, bringing their combined valuation to $1.25 trillion prior to the raise.
It is a massive consolidation of Musk's empire.
The dispatch notes this massive SpaceX prospectus is expected to go public this week, aiming for a June 8th roadshow. Now, contrast that with the defendant.
OpenAI.
OpenAI just closed a primary raise on March 31st, 2026, locking in $122 billion in committed capital.
It is hard to even fathom that much cash.
This pushes their post-money valuation to an astonishing $852 billion. But the burn rate attached to that valuation is where the true terror of the AI race reveals itself.
The burn rate is terrifying.
Projections show OpenAI burning $27 billion in 2026, scaling to a projected $63 billion in 2027.
Let's contextualize what a $63 billion annual burn rate actually represents.
Yeah, please.
You are not spending that capital on office space or marketing campaigns.
Or free lunches.
Right. That capital is being incinerated in the pursuit of raw computational power.
The compute.
It represents the mass acquisition of next-generation NVIDIA silicon, the construction of sprawling gigawatt-scale data centers, and the massive energy contracts required to power the cooling systems necessary to train frontier models.
It is physical infrastructure.
It is an infrastructure build-out rivaling the construction of the national highway system, funded entirely by private equity.
And this massive cash requirement perfectly illustrates why the capital markets were paralyzed by the lawsuit. You described the litigation as an overhang. Let's refine that concept.
It is a great way to think about it.
It's not just a dark cloud. It's more like trying to sell a massive, newly renovated skyscraper to a group of institutional investors. But there's a guy standing in the lobby with a plausible legal document claiming he actually owns the concrete foundation and he wants the building condemned.
That is exactly how risk-averse investment syndicates view pending litigation.
If you are Morgan Stanley, Goldman Sachs, or Bank of America part of the 21-bank syndicate leading the SpaceX IPO, you have a strict fiduciary duty to disclose material risks to your buyers.
You have to list everything that could go wrong in the S1.
Right. If Judge Gonzalez-Rogers had imposed even a fraction of the structural remedies Musk requested, the market would have recoiled. They would have questioned Musk's managerial discipline.
How does a CEO successfully shepherd a $2 trillion public offering while simultaneously prosecuting a $100 billion corporate dismantling of his primary AI rival?
It creates a narrative of instability.
It does.
And conversely, for OpenAI, if they were eyeing a public listing window in late 2026 or 2027, they cannot effectively market their S1 prospectus with a legally mandated risk factor, acknowledging that a federal judge might forcibly transition them back to a zero-profit charity.
No investor's going to buy that stock.
With the verdict finalized, that contingent liability is completely wiped from the ledger. The banks can price the offerings without heavily discounting the shares for litigation risk.
And we cannot ignore the parallel storyline of Anthropic here.
Yes, the quiet winner in all this.
Founded by researchers who defected from OpenAI, Anthropic operates under a similar public benefit corporation model. But while the Musk-Altman trial consumed the public attention, Anthropic quietly agreed to terms on a $30 billion raise at a $900 billion pre-money valuation.
They quietly leapfrogged OpenAI's valuation while the billionaires were fighting in court.
It is incredible.
It proves that institutional capital possesses a bottomless appetite for AI infrastructure, but it vastly prefers to deploy that capital in environments devoid of existential founder drama.
Capital craves certainty above all else.
Always.
However, the certainty provided by the capital markets stands in stark opposition to the deep, unresolved anxiety brewing in the regulatory sector.
Because the trial definitively answered the strict mathematical question of the statute of limitations, but it left the sweeping societal questions about the governance of artificial general intelligence completely unaddressed.
This is the crux of the public interest critique detailed in the CLG newsletter.
Jack Russo's framing here is brutally honest. Legally, the right outcome was reached, but ethically, everyone walks away looking compromised.
It is a tough pill to swallow.
Winning a case because your opponent's smoke detector went off 3 years too early is not exactly a ringing endorsement of your corporate soul.
Not at all. And legal scholars are sounding the alarm on the broader implications for the nonprofit sector.
Who is talking about this?
Jill Horowitz, she is a leading authority at Northwestern Pritzker School of Law. She argues that this trial represents a dangerous precedent.
In what way?
Well, the foundational logic of nonprofit law is that the state attorney general is the designated guardian of a charity's mission, protecting it on behalf of the public.
Like we discussed earlier.
Right. If aggrieved, extraordinarily wealthy founders attempt to usurp that role to settle personal or strategic vendettas, it destabilizes the entire ecosystem.
But if the law functioned perfectly and the AG is the true guardian, why is there still so much regulatory heat?
Because the regulators are awake now.
Because the source material clearly indicates that the regulatory baton has been aggressively snatched up. State Attorneys General Rob Bonta in California and Kathy Jennings in Delaware, they now hold immense leverage.
Operating off the memorandums of understanding they secured during OpenAI's recapitalization.
And the pressure is escalating to the federal level. A coalition of 10 state AGs, spearheaded by Montana and West Virginia, is actively petitioning the SEC to impose severe scrutiny on any potential OpenAI public offering.
And simultaneously, the House Oversight Committee is running probes into Altman's potential conflicts of interest.
The persistence of this regulatory encirclement reveals the fundamental structural tension at the heart of modern AI development.
We have to cleanly separate private legal liability from public regulatory compliance.
Right. The jury confirmed OpenAI doesn't owe Elon Musk anything based on the calendar, but that doesn't mean OpenAI doesn't owe the public an explanation.
Exactly. The Eyes on OpenAI coalition, which encompasses public interest organizations and safety advocates, they are hammering on a massive structural contradiction.
What are they asking?
They are asking whether the fiduciary duty to generate returns on an $852 billion valuation is fundamentally incompatible with a charter that demands prioritizing the safety of humanity above all else.
When you are burning $63 billion a year to train a model, the gravitational pull to rapidly monetize and deploy that model, regardless of safety testing, it must be immense.
So we have tangible evidence of that internal friction.
Tell us about Daniel Kokotoshlu.
The newsletter highlights his departure. He's a former OpenAI governance researcher.
Okay.
He actively chose to walk away from a vested equity package worth up to $2 million.
$2 million.
Yes, because he refused to sign a non-disparagement agreement. He surrendered life-changing wealth because he fundamentally distrusted the organization's commitment to AGI safety protocols.
When insiders are abandoning millions of dollars to maintain their right to criticize the safety culture, regulators pay attention.
The jury bypassed the ethical dilemma, but the SEC and the state AGs cannot afford to do the same.
So, if you are sitting on the board of directors of a frontier tech company today, or if you are the general counsel tasked with keeping them out of federal court, how do you adapt?
You to change everything.
What are the actionable tactical lessons from the Musk v. Altman verdict? Because this case just rewrote the risk management playbook for Silicon Valley.
The CLG dispatch identifies specific, uncompromising new directives for corporate governance. For boards of directors, the era of informal agreements and assumed alignment is completely over.
No more handshake deal.
Exactly. The new mandate is the exhaustive, contemporaneous documentation of the life cycle of restricted gifts.
So if a founder or a major donor wires $50 million to a nonprofit and verbally says, this is strictly for open source safety research, the board must essentially build an unbroken chain of custody, proving exactly how those funds were deployed, matching the restriction.
Precisely. They must eliminate any reliance on memory or assumption.
Because the trial demonstrated how violently the past can return to threaten the present.
The defense's meticulously constructed timeline was nearly obliterated by a single casual entry from Greg Brockman's journal.
That detail is terrifying from a corporate defense perspective.
It really is.
In November 2017, Brockman wrote, and I quote, "Cannot say we are committed to the nonprofit. If 3 months later we're doing B Corp, then it was a lie."
That one sentence survived years of discovery, was admitted into evidence, and provided the plaintiff with incredibly potent ammunition.
It perfectly encapsulates the hazard of internal contemporaneous thoughts contradicting the external corporate mission.
A stray Slack message, an unpolished email, a late-night journal entry. If it conflicts with a public prospectus, it becomes a multi-billion-dollar liability.
The takeaway for boards executing public benefit corporation recapitalizations is that these structures are legally durable, but they demand absolute, uncompromising internal discipline.
But the boards aren't the only ones who have to change their behavior.
Right.
The Capital Markets and Intellectual Property Council writing the actual IPO prospectuses are facing a completely altered landscape of forced transparency.
The trial utilized the power of the federal subpoena to drag the most closely guarded secrets of the AI economy into the public domain.
And Microsoft is the prime casualty of this forced transparency.
They historically defend their internal financial models with immense ferocity.
They never share this stuff.
Yet, during the trial, a witness named Michael Wetter testified in open court about Microsoft's highly confidential internal projections regarding their OpenAI partnership.
The numbers read into the trial record are just staggering.
A $13 billion investment projected to yield a $92 billion return, with cumulative revenue projections exceeding $100 billion.
Jack Russo's analysis correctly identifies that the genie cannot be put back in the bottle.
Once it is in the court record, it is public.
Exactly. Those internal models are now public baseline disclosures. When Microsoft, or OpenAI, approaches the SEC to file their S-1 registration statements, they no longer have the luxury of obscuring those financial expectations.
They must operate under the assumption that plaintiffs' attorneys, competitor intelligence firms, and federal regulators already possess their core economic models.
They will be forced to disclose their commercial terms and risk factors with a level of granular detail they previously would never have permitted.
It is the ultimate irony of the entire spectacle.
It really is.
The rigid architecture of California law functioned flawlessly to protect OpenAI and Microsoft from a disgruntled founder, dismissing the threat on a strict calendar technicality.
But the price of invoking that defense was subjecting their deepest financial and strategic secrets to the harsh, unforgiving light of the public record.
They won the battle for their corporate existence, but they surrendered the element of secrecy in the process.
A Pyrrhic victory in some ways.
When we pull back and synthesize the sheer scope of what we have explored today, the Musk v. Altman trial reveals itself as far more than a clash of massive egos or a billion-dollar grudge match over the direction of a single company.
It operated as a foundational stress test of the legal boundaries separating nonprofit charity from for-profit enterprise.
It served as a massive, multi-trillion-dollar clearing event, sweeping away the litigation risk necessary to unleash what is shaping up to be the most lucrative and historically significant IPO season in American history.
And most enduringly, it acted as a glaring spotlight on the massive, unresolved societal tension between the existential need for AGI safety and the unstoppable, cash-burning engine of unbridled capitalism.
The courtroom delivered legal finality, but the structural and ethical questions remain entirely open.
Which brings us back to you, listening.
The next time you see a headline about SpaceX filing to go public, or you read about an AI company finalizing an $800 billion valuation, you now possess the specialized knowledge of exactly how those moments were made possible.
You understand the strict legal doctrines, the calculated judicial maneuvering, and the precise statutory countdown that cleared the runway.
It wasn't the inevitable march of progress. It was a consequence of a legal clock running out in an Oakland courthouse.
Understanding the hidden mechanics of these legal victories fundamentally alters how you interpret the valuations of the companies they protect.
It allows you to see the true cost of the infrastructure. And I want to leave you with a final thought to mull over, building on the profound capital markets data we analyzed today.
Consider the mechanics of the impending SpaceX IPO.
With its unprecedented plan to allocate 30% of its shares to everyday retail investors, they are aggressively opening the doors to the public at the exact historical moment that the AI sector's cash burn rates are projected to skyrocket past $60 billion a year.
So ask yourself,
if retail investors are suddenly being invited in unprecedented numbers into the inner sanctum of tech's biggest historical boom, are we finally witnessing the democratization of Silicon Valley's staggering wealth? Or are everyday people simply being tapped to provide the massive liquidity required to foot the astronomical bill for the race to AGI, while the ultimate questions of global governance and human safety remain completely terrifyingly unsolved?
the speed of the verdict may have shattered our expectations of a prolonged legal war, but it didn't solve the complexity.
It merely transferred the massive unresolved risks of AGI from the courtroom docket directly into the global capital markets.
Tune in next time on The Valley Current.